Welcome everyone to our event tonight. I'm really very excited about this one. This is one of those ideas we had a few weeks ago that seemed almost necessary to do. There's so many things that are happening in our time right now that are unprecedented. And I know that's cliche, and you've heard a million people say that kind of thing in the last several months, but it is true. It's cliche for a reason. We're in a sort of uncharted territory in 100 different directions, including legally. And one of the most often repeated questions that I get is, how can they do this? And how can we do what we're doing as it relates to government action? And so today, to explore that topic a little bit, we've invited a panel of 3 individuals that have a lot of expertise in this area to help us unpack that a little bit and learn more about exactly what the government can do, what it can't do, what it might be doing right, what it might be doing wrong, and what the legal implications of all of these questions are on our lives as we kind of try to push forward in this new time of coronavirus. So just to quickly introduce our panel here today, starting off, we have Keith Jacques. He's worked as a civil trial lawyer for over 25 years, successfully representing plaintiffs and defendants in complex commercial cases, personal injury, products liability, medical malpractice, business and contract disputes as well. He's represented individuals, small businesses, and large companies in a wide variety of commercial matters and is frequently asked to mediate civil disputes. He currently serves as city solicitor for the city of Biddeford. Patrick Strawbridge has represented a broad range of individuals and institutional clients on matters of constitutional law, financial and securities regulation, environmental laws, complex commercial disputes, and consumer protection statutes. He provides clients with advice and representation at pre-litigation, trial, and appellate stages. His experience includes arbitrations, trial, and appellate litigations, and administrative and regulatory proceedings. And you might have seen Patrick in the news recently because he is currently representing the Trump administration in front of the Supreme Court on the question of the tax issue, on whether or not the president is required to give his tax returns to the public. We also are joined here by Sigmund Schutz with courtroom successes for public companies, regional businesses, insurers, and entrepreneurs. Sig Schutz is a trial lawyer with more than 20 years of hearings to his credit, including jury trials in state and federal court, multi-week complex arbitrations, and high-stakes administrative hearings. In 2000, Sig won a $13.6 million jury verdict in a complex business case, and he's been counsel of record in many state and federal reported judicial decisions, including nearly 30 appeals. So we have a wide variety of experience here and perspective on a number of issues that are facing us. And so to begin things out here, I'd like to welcome the panel. Thank you all for joining us here to provide your expertise to us today.
Thank you, Matt.
Happy to have you. So I'm going to start off, and the way that this is going to work is I'm going to ask a question and I'm going to let the panel take it. So I'm going to just go ahead and get things kicked off right here with perhaps the most simple and yet oft repeated question that I've gotten from our supporters as well as people that I've just talked to in the general public. In response to a situation like this, where a virus is spreading through the country and governments are seeking a lot of power to try to respond to it, there have been a number of curtailments on constitutionally protected liberties that citizens have enjoyed for a very long time. And our lives have changed. We've been under quarantine, businesses have been forced to close and change practices, etc. Most of this is done with emergency power declarations, and you saw Janet Mills just issued an extension on her emergency powers through June 11th, starting yesterday. She made that extension, and the executive orders that are signed within that. So my question to the panel is the same one that I'm getting. How is any of this constitutional? I don't know who wants to kick things off here, but I think that's the big question of the day.
I'm happy to take the first swing, and then everyone else can correct me. You know, the first question one gets when they ask what is constitutional, the question is, well, what part of the Constitution and which Constitution are we talking about? The federal Constitution that we have gives the federal government enumerated powers, limited powers, and it reserves through the 10th Amendment to the states all powers that are not expressly conveyed to the federal government. And the general rule when it comes to public health, public safety measures is that those are primarily the state's powers. The federal government doesn't have a primary police power, as we refer to it, but a general power to regulate in the name of safety or health or welfare. That's generally a state power. Now, there are individual constitutional provisions that may come into play from time to time. The federal government obviously is charged with issues surrounding quarantine, particularly with respect to immigration from foreign countries and travel between the United States and foreign countries. The First Amendment can impose some limits on government action, even in times of emergency. And there are maybe a couple other provisions here. There, possibly the Privileges and Immunities Clause of the 14th Amendment, that may have something to say about state action. But that's going to be far and few in between. For the most part, you're going to have to look to state government and state laws to determine whether or not emergency powers or emergency declarations push constitutional boundaries. And as we may have learned, or some of us may have learned for the first time in this process, Maine's legislature and Maine's statutory scheme actually gives a fair amount of power to the governor to declare emergencies and to assume emergency power, which include, and I'm not making this up, it's right there in the statute, to suspend laws and rules as necessary to meet the threat. I think that there's some consideration, probably properly so, that maybe needs to be changed. It's probably not going to be changed anytime in the middle of what we're enduring right now. But we start from the process that this is a decision largely for the states to make, and Maine at some point in time has made the decision to give the governor a fair amount of power in this area. That is not to say that the power can be exercised arbitrarily, and we can talk about ways or specific scenarios to challenge this. But the first question is this constitutional? The answer is going to be mostly yes, and it's going to be very difficult to convince a judge, state or federal, to challenge directly the authority that has been given to the governor by the people of Maine through their legislature. So that's a very high level answer, and there's a lot of there's a lot of devil in the details that we can discuss further. But that's one way I think it's useful to start answering the question.
And I think Matt, that I tend to agree with Patrick that I think it's going to be very hard, at least where we are right now, against the background of the pandemic and historic police powers that have happened in the past, to come in and say that the stay-at-home order, which is probably the most concern of most people, is unduly burdensome and somewhat unconstitutional, particularly when, at least initially, I think the stay-at-home orders, not only by the governor of the state of Maine, but also elsewhere in the country, they're not meant to be a permanent state of affairs, but almost like a timeout period. You can tell I've had kids, but a timeout or a holding pattern to get various states ready for what is the next phase when it's safe to do so.
And I'll just add, I mean, the states derive their legal authority to impose public health interventions from a general police power, which includes an obligation to protect public health. Now, that power is reserved to the states under the 10th Amendment to the US Constitution, and it's described as a very broad power. And that power is typically only restrained by state statutes or the federal state constitution. So the answer to the question, I agree with Keith and Patrick. I mean, are there limits on federal, state, or local emergency authorities? Yes, but the scope of those limits is unclear and complicated. And some states have substantive or express limitations on these emergency powers, either by executive order or otherwise. There are, in some instances, procedural protections, and laws vary widely, and sometimes a court order may be required, or some other form of judicial review may be available. And finally, there's the question of constitutional, both under the federal or state constitutions, constitutional limitations on state power. And prior to this pandemic, we look back to cases at the turn of the century involving the flu and so on, cases involving things like mandatory vaccinations and quarantine orders. And that old authority does suggest that emergency government powers are not unbounded, and they have to be exercised consistent with certain first principles. But the courts tend to defer to the executive branch in the exercise of these types of powers to protect public health.
Great. Well, that's a good way to kick things off here. And by the way, I should mention, since we have so many participants on this forum, which is fantastic, by the way, thanks everybody for being here. The chat room in terms of questions being submitted as we're going, I'm not sure we're going to really get to many of those questions because a lot of you submitted questions ahead of time, and I've got a pretty long list as it is. So I'll just say this to the panel. If you see your little chat window there, and as we're talking, if somebody has a comment or a question that's related to what you're saying at any given time and you wanted to kind of use that as a jumping off point to chat really quickly about something that you're seeing addressed there, please feel free to do that as we're talking. But just for the rest of the peanut gallery, if you're out there asking questions on the chat, I'm not sure we're going to be able to get to many of them, so just FYI. So the second question is sort of related to the first, and this is, I think, born of not only my own legal lack of experience here, but a lot of other people's. But you know, doing cursory Google searches and whatnot, we always see things that say that in order to restrict individual rights, so far, the government actually has to have rules that are narrowly tailored to fulfill a legitimate purpose while limiting the freedom as little as possible. And the question really becomes then, do the broad shutdowns of entire states, the kind of things that we've seen in these orders so far, does that meet the standard for trying to narrowly tailor these orders to restrict freedoms as little as possible? Or is there room there to challenge sort of the broadness of it all?
You know, the specific constitutional standard really kind of varies based on what is the alleged right or constitutional prohibition that's being challenged. So you've seen some success in some jurisdictions with challenging overly restrictive prohibitions on gathering for speech in the form of protest or for religious worship. And that's because the First Amendment provides, you know, a dedicated protection for speech and for the exercise of religion. And the courts have imposed a pretty high standard for government action that restricts it. And so even in the face of what is generally considered, I think, probably a situation where the courts are going to lean highly deferential to government action, there are still limits. And the First Amendment is probably the strongest bulwark one has if one can fit their claim under the First Amendment. And so in other jurisdictions, you know, prohibitions on any gathering for church worship have been struck down as not sufficiently tailored or not containing enough exceptions. For example, I think that the Kentucky case did not permit, you know, drive-in services where people could still remain in their cars and maintain a safe social distance. And so that one has been struck down. In Maine, we had the case of the church in Orrington, and at least on a temporary restraining order, which is a fairly light standard and kind of a quick order, Judge Torreson decided that Maine's order provided sufficient flexibility to ensure drive-in worship could take place, and the restrictions beyond that were not sufficient to violate the First Amendment, at least in terms of the sort of preliminary view given at the TRO stage. I do see some people asking in the window, I just thought I'd address it really quickly, as to whether or not the statute that gives Maine's governor the power she has, or the office, in this case, Governor Mills has in the time of emergency, is itself unconstitutional. And there's an interesting separation of powers issue that could be explored there, whether or not this amounts to giving legislative power to the governor, and whether that can be viewed as consistent with the way that the Maine government is structured in the Constitution. I'd say it's interesting, which does not necessarily mean it's going to be compelling, especially if you ask an individual Superior Court justice or members of the law court to try to make that call in the middle of a public health emergency. They would probably focus on the fact that the statute does bound the governor in some ways. It imposes a few conditions on emergency proclamations. They have to run for 30 days at a time, and presumably nothing stops the legislature, if it's really upset with what the governor is doing, from trying to reconvene and restrict her powers. And my guess is if you actually try to challenge it in court, the courts would ultimately determine that this did not cross the line of separation of powers. Not saying that that would not necessarily be the right or the wrong decision, but realistically, I think that's what would happen.
And I think particularly without having some legislative intervention, in other words, the legislature coming in and trying to challenge that the governor's usurping her powers, I think it'd be a really tough argument before a court. I think there was a Wisconsin Supreme Court decision recently that came down where the court sided in favor or against the governor continuing to exert some of her emergency powers. That was a challenge that was brought by the legislature, basically saying that she was stepping on their feet, basically, and starting to take a lot of legislative power that she wasn't entitled to do so. I think as long as the legislature here sort of steps back and doesn't do anything to challenge the exercise of emergency power, the court's going to be hard pressed to get involved, particularly given the current, frankly, status of the court system right now with the shutdown.
Yeah, I mean, the question was about overbreadth. I mean, I think that is an interesting area, and it can come up in the instances where the government arbitrarily discriminates in favor of or against certain groups or potentially certain types of businesses. In the foundational case on the scope of public health authority from the US Supreme Court is a 1905 case, Jacobson versus Massachusetts, in which the Supreme Court upheld the authority of states to mandate vaccinations, in that case, smallpox. And the decision simultaneously recognized, on the one hand, broad public health authorities for states or localities, as well as limits on that authority. The court referred to limits where the state acts in an arbitrary or an oppressive way, or where the state acts where there's no real or substantial relation to the goal it's attempting to accomplish, or where there's a palpable invasion of rights. And if you think about that case, I mean, if you can't protect your own body from being physically invaded by vaccination, whatever your view of vaccinations is, the court isn't likely to concede that you have a right to speak or worship or even use your property in a way that isn't harmful to others. So I think that is an important case, and that is the most recent pronouncement from the US Supreme Court, although it's from 1905.
I'll just follow up really quick, Matt, and maybe this is where to go. And I think that Sig makes a good point, which is that, we've mostly, I think, been, giving everyone the bad news here. The bad news is, I think we're all aware of how frustrating the assertion of state power is in this case. And I think we're all keenly aware of the economic damage that is resulting from the whole situation, and how much of that you want to attribute to the government's actions or to the crisis itself is a fair game, and there's a lot of room for debate. And I'm sure that we all have disagreements with the categorizations that have been made in some of the government's orders so far. And the closer you can get to demonstrating a truly arbitrary distinction between businesses, the better off a chance you are maybe of challenging this. And one that springs to mind, for example, and I'll admit that I haven't gone to the next level and looked at the regulatory guidance on this, but I know, for example, right now the scheduled reopenings distinguishes between bars and restaurants. And it's not entirely clear to me that in all cases that is any somewhat arbitrary distinction, because whether or not one is a bar or a restaurant doesn't really have a lot to do with necessarily how closely people are packed together or how virus might be transmitted in a particular space. So theoretically, there might be room to make challenges around the edges of these orders, particularly to the extent that you think one class of people is being characterized differently than another, totally inconsonant with the risks. And I see someone in the chat has brought up the Ebola quarantine case from a few years ago under Governor LePage. That case ultimately settled, but the initial ruling by the Superior Court in that case found that the quarantine order on her was overbroad, and it did so based on the view that the quarantine restrictions that were being imposed were only consistent with an airborne transmission, and there just simply wasn't any evidence in that case of airborne transmission of the Ebola virus. So it felt that the restrictions were overly broad, but it did uphold the ability to impose some restrictions even in that case. I also just think that the reality of, a few examples of Ebola, which, perhaps justifiably were causing a lot of concern, are just not going to be treated the same way that the kind of, obvious pandemic and with substantial national consequences that's happening right now are. The courts are going to be far more reluctant to intervene or to second guess executive decision making, whether it be Democrat or Republican executives, in this scenario. But I don't mean to suggest that there's no route of appeal here, and we can explore some of the other scenarios. But I think we're just trying to be realistic. It's the states under our constitutional system have broad power, and it's difficult to challenge in this type of a scenario.
And you can look back to, for example, the Jacobson case and say, okay, that's a 1905 case, and that's, is that still precedent? But it is, and that case held pretty strongly that there's no constitutional right for a person to be free of every restraint, that basically as a condition of citizenry, you're subject to a form of restraint for public good. And later on in 1945, the Supreme Court, in connection with the vaccination case, again, talked about the state's rights to public safety. And so those are just tough burdens to overcome. particularly when, as I think Matt said at the beginning, this is sort of unprecedented. This is, we're all learning as we go somewhat, not only legally, but also medically, and from a government perspective as well.
To keep going, I'd love to kind of continue this conversation with a sort of related question. I've seen a number of questions or comments in the chat about the sort of the extension of the emergency order and who the arbiter of what emergency is or isn't and what authority that's really granted. Governor Mills announced yesterday, as we all know, that she's issuing another extension on the civil state of emergency till June 11th. And this is now the second extension since her original order on March 15th. And that means that it's now going to be at least, probably more frankly, but at least 3 months of the year where you have self-appointed emergency authority by the governor resting in the hands of the chief executive. And this concentration of power is pretty troubling to a lot of people. So the question really is this: are there any legal constraints on these emergency powers and declarations? Can they continue on forever? Is there any legal recourse to restrain that power or at least subject it to legislative review? And is there any sort of arbitration on what is or is not an emergency somewhere? It's a pretty big question, but I'd love to get your thoughts on it.
The statute itself's language is pretty broad, and I've got it in front of me. It basically says, and I'll paraphrase, that whenever a disaster or civil emergency exists or appears imminent, the governor shall, by oral proclamation, declare a state of emergency. And it doesn't really provide any sort of definition as to what is the civil emergency or what is the disaster that's being contemplated. It just gives the governor fairly broad powers to declare a civil emergency. And I think, barring the legislature coming in and trying to pull those rights back, frankly, come June 11th, I think she has the authority to declare another state of emergency.
Yeah, I mean, go ahead, Sig.
I just was briefly going to say, I think that the answer to your question, Matt, depends on the nature of the nature of the rights that are affected by these emergency orders. You know, the scope and content of these orders varies state to state very, very broadly. We talk about let's talk about an invasive or controversial public health intervention, such as depriving people of personal liberty, forced testing, forced vaccinations. How about the power to apprehend and detain individuals or groups in mandatory quarantines, potentially isolating people to quarantine them. When you start getting into the more extreme exercise of power, that's where there's a greater likelihood, I think, of successful challenges and successful judicial review, where there's more of a light touch, guidance or suggestions or recommendations or even requirements, but they're not really enforced. I think that's, easier for the government to try to get by with that stuff than engaging in these kind of more extreme types of measures.
And I think that perhaps if you're going to challenge the governor's actions, it's not so much challenging the declaration of a state of emergency, but rather the individual executive orders that follow that, basically, because that's where the real actions and prohibitions are being taken.
Yeah, I would say that the statute does impose some deadlines. It does impose some requirements. I think that there's if the state of emergency extends 90 days, there's a requirement to convene the legislature by the 80th day. I think there might be some open to interpretations as to what's an extension of an existing order versus what's a new emergency order. So there are some limits on this, and the legislature always has the power to act. I do want to just emphasize a point that, those of us who lean conservative ought to believe, or at least in my view, shouldn't give short shrift to, which is that, the legislature ought to be the primary source of how we make our decisions. And it's always frustrating when we kind of find ourselves in the middle of the situation that we didn't realize what the legislature had done. But the courts, we should not, in a normal situation, be looking to the courts to make the hard decisions that need to be made through the democratic process, like how much power we're going to give to the various state departments in the middle of emergency. So I don't know that it's necessarily a bad thing that the road to court enforcement or court challenge to these types of orders is difficult, because I think normally we want the people through the legislature to make those decisions and not leave them to individual judges. So I guess from that perspective, from a structural perspective, I don't really have a problem. I guess, you know, obviously what this has shown a spotlight on is just how much power the legislature has conceded away to the executive. And that may not have been a wise decision. I think there are certain members of the legislature who are regretting that right now. And so that's something that, you know, I hope people take to heart, both those who are in the legislature as well as those who vote for the representatives in the legislature. Those votes matter, and the statutes on the books matter tremendously in these areas where the courts are going to be particularly reluctant to intervene.
All right, moving on here. Yesterday, the Wisconsin Supreme Court issued a close decision striking down Governor Tony Evers' decision of that state's stay-at-home order. The decision limited his authority to make statewide rules during emergencies, and it required him to instead work with the state legislature regarding actions to mitigate the outbreak. The justices wrote that the court was not challenging the governor's power to declare emergencies, but, quote, in the case of a pandemic which lasts month after month, the governor cannot rely on emergency powers indefinitely. So this sort of dovetails with what you guys are all talking about already. But what is your thought on that decision? And do you think it is likely that legal challenges to stay-at-home orders specifically, like this one in Wisconsin, would be fruitful in other states, and particularly Maine?
I mean, so fundamentally, my answer to that is no. And it's for a couple of reasons. One, the Wisconsin statute is different than the Maine statute. And as I recall, I read that decision briefly last night. The Wisconsin issue there was the governor had a limited period of time in which he could actually issue an emergency order. It then fell, the question then was whether or not the governor could basically delegate to the commissioner of their health department to impose longer restrictions. And the court essentially held that under Wisconsin law, that power did not exist without at least going through normal notice and comment rulemaking procedures, and that there was sufficient time to conduct those procedures, and that without having, that the pandemic did not give a license to simply ignore those procedures if you were going to be imposing new rules. So it didn't, I think, even necessarily hold that the HHS ultimately couldn't impose those provisions, but I think it did hold that they had to do them through the normal statutory processes, which of course they were not interested in doing. You know, I would also just say that Wisconsin has an elected Supreme Court. It's a bitterly divided court, I think it's fair to say, and it is willing to enter into the fray in these issues, perhaps more so than I think the Maine courts are, which tend to be fairly deferential in these aspects. And I have been in the situation of arguing in favor of that deference. You know, the governor, former governor at least, and I've been in the position of challenging that deference, and it can be very frustrating for litigants and for advocates alike, the degree to which the Maine courts are sometimes especially deferential to state action, although maybe not for Keith, since that probably benefits his client a lot. But it's just how it is up here, and I think that the courts are particularly reluctant to veer away from that process.
And I think a distinguishing feature in the Wisconsin case is that was a case where the legislature acted to try to rein in the executive powers of the governor. And I don't think you're going to see, at least I don't believe you're going to see the Maine legislature act in that way. I mean, I think you've got a legislature that before adjourning in March actually gave the governor additional emergency powers, or at least brought in the emergency powers that she had. And so I think if any lawsuit that would be brought similar to the Wisconsin court would be framed much differently, because it would be brought by either individual citizens or a group of citizens as opposed to a legislative action against the governor.
All right, continuing on, we have a question from Bob Fuller. While it seems unlikely to me that the legislature has any immediate role to play in the current scenario, though I welcome your thoughts on the issue, what sort of legislative response to similar medical emergencies do you foresee emerging? And could you give us your thoughts as to what sort of legislation might be beneficial and what sort would not? And this goes into what I think I've seen on a number of folks in the chat, asking the question of what you might recommend. Put on your advocate's hat for a minute and actually just tell us what you think might be prudent for us to explore in the aftermath of this to try to make this system better. Who wants it?
I'll just say, raise one issue, and one of the checks or questions that this raises. We've been talking about opportunities for judicial intervention. Patrick raised correctly the fact that the legislature has a key role in making the law, and ultimately, the buck stops to a large degree with the legislature when it passes laws authorizing the governor to exercise wide authority. But there's also the question of federal power. And there is some question about what the scope of the federal government's authority may be to intervene or potentially take decisions at odds with the decisions taken by the states, either in a mandatory type of way or by using the power of the purse and the other levers that the federal government has to persuade, cajole, and convince the states to go along with the federal government's bidding. But I'm sure this pandemic will generate a lot of new legislation. One of the most important pieces seems to be better coordination between the federal government and the states, and perhaps between neighboring states, because there's such a patchwork of responses to this pandemic across the states, often without much coordination between the states. And in some cases, limited coordination with the federal government. So you've got different states working at cross purposes with one another, perhaps acting independently of the federal government, taking potentially divergent decisions that are at odds with one another, and rather than be mutually reinforcing, are mutually undermining. So I think that is one of the outcomes of this, is probably going to be a major federal effort to get new legislation pulled together and to respond at that level, and to look for ways to better coordinate with the states in ways that are protective of public health and protective of civil liberties.
I think, there's a lot that the legislature could do. You could look at the provisions of the statute, in this case 37B, that gives the governor these powers, and there are some exceptions to that. For example, the governor is not allowed to exercise eminent domain power pursuant to an emergency proclamation, and there are also restrictions on the governor's ability to suspend certain environmental laws during an emergency. And the legislature could easily impose other restrictions if there was going to be effects on private businesses that were going to exceed 2 weeks. It could restrict the governor's ability to do that, or require the legislature to be called into session after the first 30 days of an emergency proclamation instead of 90. There's lots the legislature could do, assuming that it can get the necessary majority. And I suppose, not to inject another contentious issue into this, but I suppose there's always the possibility of using the referendum process to attempt to impose controls on the statute too. But there are things that could be done if people are uncomfortable with the amount of power that the governor has in this case. But I do think they're best going to be done through regulations as opposed to authorizing some type of court action. I've seen one thing popping up in the chat, which is at least tangentially related to this, which people are asking about, well, what about enforcement? Who does enforcement fall to, and what is the ability of what is the discretion for either localities and or individual law enforcement offices to choose not to enforce? And I do think that there's a lot about these orders that are not self-enforcing, and that generally require some degree of cooperation, if not from local authorities, from the populace. And I think an example of that, and one of the more controversial examples in the current emergency proclamation, is the 14-day quarantine for out-of-state residents. I don't think there's really a meaningful enforcement mechanism in place for that. They can impose penalties for people who are caught doing it, but I don't think, they're not shutting down the borders. They're not turning people away. They're not doing anything that I'm aware of that can meaningfully determine whether or not people who are coming into the state right now are actually barricading themselves in their house for 14 days with food they brought in from out of state to prevent themselves from, having any contact with people in Maine. And individual officers are obviously going to be empowered as to whether they tell someone, on the beach to politely move, or they take them into custody and arrest them. And the enforcement of this may give rise to claims of arbitrary processes by the law enforcement officers. So I just wanted to flag that to say that it's not necessarily clear that all of these powers can be meaningfully enforced by the state government. And I think you're seeing that a little bit And I think you're seeing some concern about the political process, at least in some of the progress that has been made in getting the governor to accelerate the opening of businesses in counties that are not nearly as affected. A lot of people are noting, I think rightly so, that a lot of the rural counties just simply do not have the same problems and probably are not subject to the same risks that the urban counties are, and it doesn't make a lot of sense to treat them differently, and at least there's been some modest progress in that direction. But ultimately, political actors, whether they be the governor or the legislature, respond to political pressure. I mean that is the goal. So the more uncomfortable that the citizenry feels and the more willing they are to take that out on their elected officials, the more likely you are to see the elected officials respond to those concerns.
This, I think, is also related to another several questions I saw in the chat, which is actually nicely combined with one of the questions I was planning to ask you anyway. So that question would be this. If I put you in charge, deputized you to be the attorney of record in this, and asked you to go beat up on these restrictions and to attack them and try to roll them back in some fashion, and I gave you an unlimited budget to do it, and you just were able to do whatever it was you thought was most fruitful, how would you attack these rules and regulations now? How would you go after this to try to get some of these things, some of these restrictions undone? Or is that fruitless? Should we do that? Should we not do that? But that idea of having unlimited money and going after it right now, it would at least provide us some sort of idea of what's possible.
Well, I may be on the more liberal side of Patrick on it, but I don't think that the mechanism is to try to attack most of this stuff legally. I think there's got to be some effort done in Augusta to try to control the message a little bit and try to control what can be done. What are where the areas that we can continue to loosen these requirements? And at the beginning, I talked about how these stay-at-home orders aren't meant to be a permanent structure. It's really a time for people to step back and then try to rationally get to the point where we can reopen the state while still protecting public health and safety. And I just think there has to be more messaging going on to try to create ways to be able to do that.
I'm not sure if the panelists have any other, but I guess really the core of it is, even if it's things that you're doing on the edge of what the government is doing right now. I mean, the big concern among many of us right now is that whether it would survive in court or not, these assumptions of massive powers by state governors particularly are a big time threat to human liberty in general, and we're pretty uncomfortable with what we're seeing. So how do you try to push back against that, legally speaking, or is it even not possible?
Yeah, look, it is possible. You can take a shot. You could argue for a rather robust interpretation of federal privileges and immunities that would include interstate travel, for example, and you could try to attack the 14-day quarantine as unwarranted given what the experience is in other states and the lack of evidence and perhaps the ability of least restrictive measures. You could certainly mount any number of challenges to what you would consider arbitrary or capricious divisions between which businesses can open up, which locales are under severe restrictions versus less severe restrictions. There are ways to do that. I think a more effective line of attack, if you actually had the ability to fund it and do it, and Sig can probably speak to this, is transparency laws. I think certainly in this situation, there should the need for transparency in public decision making is very high. And I think there is justifiably some frustration about the way that the legislature has been cut out of the decision-making process by the executive branch, whether that's pursuant to their statutory power or not, as well as open meetings issues and open records issues. And I think Sig can probably share some rather disturbing justifications that have been offered in respect to some FOA assertions by the Department of Health in Maine. So there are ways to attack this, but the easiest way is going to be to bring about the political pressure that will convince people to do it up. I think Sig should respond to that, in part because he's the state's preeminent FOA expert. But I also I will be happy to address the contact tracing hypothetical, which is coming up a lot in the comments. I know people want to hear about that, but we can come back to that in a minute.
Absolutely. And Sig, actually, that's perfect to toss to you right now, because one of my next questions was actually going to be about these transparency laws. And, you know, the governor was caught having secret meetings without notifying the public. You've got the legislature cut out of a lot of things. You've got a lot of municipal questions, too, about notice and how meetings are done and public testimony and so many other things. What does the world of transparency in government look like after this?
Well, it hasn't been good. It's taken a big hit as a result of this situation, and we, the people, are much less informed about what our government is up to, as well as the basis for their decisions about this situation. In the name of frankly, for the stated purpose of suppressing information, the CDC is withholding data that is public data that we ought to have to make our own value judgments and make our own decisions about the propriety of the decisions that are made by the state to lock down different counties or justify emergency orders and so forth. I mean, without access to government information, can't make informed decisions about these policies that are being, in some instances, shoved down our throats. So I think there's a big transparency problem right now in state government, and one of the stated justifications for suppressing information on COVID-19 cases by municipality is to keep as many people scared as possible, to keep people indoors and compliant with emergency orders. I mean, that's the stated justification for suppressing this information. Now, my view is, whether it's public record or not, it should not be the product of a value judgment as to it's our information and we ought to have access to it, and we then can make whatever decisions we wish. Back to your question, Matt, I mean, I don't think a court challenge is probably a prudent expenditure of a lot of money. Not that it would be hopeless, but I think the odds would be long for success. I think some of the other steps that people are taking, some civil disobedience, the protests, the advocacy, with the legislators, organizing, those activities, I think, are more effective ultimately in persuading the governor and legislators to take action than a courtroom battle, because the courts, frankly, just aren't really equipped to understand or weigh in an informed way the science and the public health policy issues. And I think in most states, including in Maine, the courts are reluctant to second guess, the PhD scientists who come in with the fancy resumes and so forth when it comes to making these types of decisions. Now, as time moves forward and the kind of urgency of the situation starts to abate, or to the extent the government starts taking really dramatic steps, mandatory steps, there I think the courts may be more willing to step in.
All right, great. So let's continue on. I know, Patrick, you'd mentioned a moment ago that it might be a good time to talk about contact tracing, and that actually was one of my questions anyway. The extension of government power in a situation like this to be able to literally track you, keep information on you, your movements, what you're doing, who you're with, etc., is a very big concern for a lot of people. And the governor has already started requiring restaurants, for instance, that reopen to keep tabs on who is actually showing up there, so that they could be that information could be given to the CDC in the event that there is some sort of an outbreak of COVID in a restaurant or some other location, and they want to trace who they had contact with. So as it relates to contact tracing, is there any sort of constitutional question that you think exists there? And I certainly would think so, but I'm not a lawyer. So I'd love to get your thoughts on exactly what the constitutionality of that kind of action is and whether or not there's a challenge there.
Yeah. I mean, the answer to that is yes. When we start talking about some of the more extreme measures here, such as contact tracing or physical, separation orders, that sort of thing, it gets much more difficult, I think, for the government to justify that, because you're going to have some serious constitutional concerns come into play. Now, a lot of it depends on what's done. Contact tracing is done, for example, as I understand it, in South Korea, I think would run into a number of obstacles here in terms of, mandatory, essentially like geo-monitoring of people, forcing people, even those not showing symptoms or not demonstrated to have been in contact with somebody with an infection, requiring them to physically stay in a particular location for a period of time, essentially, either requiring people to have on their phone and to check in period of time. So that's going to raise a lot of issues. It's going to raise a lot privacy issues, Fourth Amendment related issues. And I don't think that the government's going to be in a position to kind of impose that draconian style of contact tracing on everybody just as a matter of public health. Now, contact tracing as a condition of taking advantage of certain, businesses or aspects is a different question.
I think we might have lost you there, Patrick. If you can hear my voice, you froze on us. I'm not sure if any of our other panelists want to take over some thoughts on that really quickly before we move on, but hopefully we'll get Patrick back here in just a second.
Well, I think what Patrick's talking about is it really depends on the degree of the contact tracing and how limited it is. And the broader it is, the more likely it's going to be subject to some challenge. And the more limited it is and the more short-term it is to enable to achieve a legitimate government interest, like being able to reopen restaurants, bars, stores, I think the more likely a court's not going to have a real concern with it.
All right, so moving on with my next question here. In the aftermath of COVID-19, there will undoubtedly be a vaccine that is developed to help fight infections. The government will likely do everything in its power to convince and cajole the citizens to get the vaccine to protect themselves. Obviously, last year, Maine lived through a debate on government power to mandate vaccinations as a prerequisite, for children to attend public schools. But in this instance, there's the possibility that in Maine or other states, they may attempt to order all citizens to actually be vaccinated against COVID-19 to try to fight against it. The question I have for you then is, what are the legal implications of such an order if it were to have been issued?
I mean, I can start. I mean, we talked about the Jacobson case from way back in 1904 or so, which was a vaccination case. And then I know more from the school law side of things, but there are subsequent cases in the 1920s and 1940s that sort of upheld the government's right to require vaccinations, subject to some exemptions. The one that's probably most prevalent is the medical exemption. But I think particularly given what the country's been through, even though we've got a very different Supreme Court than we did back in the mid-1900s, I think we're going to have a difficult time having a court determine that you can have required vaccinations if and when they become available.
Yeah, I think, under the law as it exists now, the constitutional law, as long as health authorities can show that there's potential exposure and risk to society, number one. Number two, that the vaccine is safe to a reasonable extent. And as long as the vaccination law, such a law, were not discriminatory, it would be constitutional.
And Patrick, I saw that you have rejoined us now. I'm not sure if you caught my question, but long story short, if the government or private enterprise develops a vaccine and then issues an order via the state government and the, for instance, to have their citizens actually be vaccinated in a very broad order that's frankly just for being a citizen of the state of Maine, is there legal standing to challenge that and have any sort of order like that rescinded?
There is standing. I think SIG accurately stated what the case law has previously said, which is generally those can be enforced. There are some interesting questions because I think there's a shift in the law underway right now as to whether those who have bona fide religious objections to receiving vaccines might be able to exempt themselves from an otherwise generally applicable law. The rule has been no for a number of years under a decision called Employment Division versus Smith, authored ironically enough by Justice Scalia, basically saying that the free exercise clause does not impose any requirement for a general religious exception to an otherwise applicable law. But I do think that that law in that area is moving right now, so it's not entirely clear that at least there might not have to be some kind of opt-out scenario, at least for those who have sincere religious objections.
Yeah, Matt, I'll just add that, with regard to privacy, you accept this is an infectious disease. It does change the calculus because there is greater connection between someone else's health and the rest of the public's health because it's an infectious disease. So the notion of how privacy works in a situation where we all to some degree have a greater interest in the health of others in our own community, I think may move the needle on this a little bit.
Just ask the residents of Vinyl Haven.
Well, right. Exactly.
Moving on, I do want to try to get through as many of these questions as possible, and we're sort of winding down the amount of time we have available. The question that I'm going to ask you next comes in from Steve Hanley. He's asking this. There have been persistent rumors that the governor is seriously considering waiving the need for school budget validation referendums this year. This would be an outrageous infringement on the right of voters to control their local property tax destiny. Number one, can she actually do that legally within the framework of current law and how everything is structured right now? And question two, I suppose, would be, if she does it anyway, will anyone have the motivation and means to fight it?
I think under the governor's emergency power, she does have the right to suspend the enforcement of any statute, basically, as well as a variety of others. So I think she probably could if she wanted to. I didn't hear that she was intending to do that, so I really can't comment on whether that's in fact going to happen. But I know a number of municipalities are still having state election, have primary elections coming up, and I would assume that those referendum questions, I know in Biddeford, it's still intending to be on the ballot.
Yeah, I think it's worth noting that the more attenuated an action under the emergency powers is from the actual emergency, which again, even under the statute, it's supposed to be a 90-day period before the legislature gets back involved. When you start talking about, not just making delays or the temporary suspension, but fundamentally changing some of the structural provisions, whether that be ballot, going to the ballot box, or how you vote, I think there's a greater chance that you could successfully challenge that as outside the scope that was delineated to the governor. Now, I'm not saying it would be successful, and I think that Keith may well be right that at least in the short term there's no problem. But that's an issue that's popping up a lot in the election cases. I mean, there are a number. I think there's over 24 suits now in various states that are either having primary elections or the upcoming general election. And there's arguments by both parties that they should expand mail-in voting, reduce voter ID requirements. Literally the same parties have taken the position that in-person voting should be canceled in some states and has to proceed in others. There's a lot of scrambling going on, and there is a lot of funding for that type of challenge. And election law is kind of its own area that has some of its own unique considerations because there are some federal guarantees that come into play there. But I do think that the more structural changes that one makes and the closer one gets to other constitutional guarantees. We talked about religion, we talked about speech. I saw someone in the comments had a question about the Second Amendment. When you start getting into enumerated rights under the federal Constitution or voting, different interests are going to come into play. And the chance that a court, either a state court or a federal court, if there's a federal right involved, might be willing to get in and start drawing boundaries increases.
And I think, Matt, that goes back a little bit to a question you had raised a while ago, which was some of the things that we'd like to see the legislature maybe do when all of this stuff is by us. And it strikes me that one of the things that needs to be done is to take a look at the state's election laws and to start creating a better framework as to what happens when we're in the type of situation we're in now. How do these elections go forward? What protection do we have to make sure that the elections in fact are legitimate, and how do we address various things, and not only elections but also town meetings and everything else? Because I know, having spent a fair amount of time recently talking to municipal officials, they're sort of struggling as to the best way to run the elections, what's being required, what's not being required, and I think guidance in the future. I don't think it's enough to just say, well, we had elections during the Civil War, we had elections during World War II, so we'll have elections now. I mean, this is a situation where people potentially are scared to go to go vote, and so what sort of things do we need to do to enable people to be able to vote without feeling that they're endangering their lives?
One of the things that has been in the news, obviously, in Maine the most in the last couple of weeks has been the sort of civil unrest you're starting to see, not only the protests, but also the defiance of the emergency orders, like with what you saw with Rick Savage and the Sunday River Brewing Company. Is it lawful to imprison or penalize, frankly, someone who defies an emergency order like he was doing? What recourse do people like Rick Savage have in opening their businesses in defiance of this order? Is that something that you might even recommend or caution against? Can the state permanently rescind their licensing status as a result of this? What are these implications?
I mean, in that particular example, I think that the biggest leverage that the state had was the liquor licensing, which is rather, the state has a lot of power to impose restrictions on your ability to sell alcoholic beverages, as opposed to just your general ability to open an ordinary business. The more highly regulated the business you are, the more likely it is that there's going to be some regulatory provision that can independently serve the basis as part of the bargain of doing business, because you're going to comply with all state laws, you're going to comply with all duly posted orders, either from the agency or in this case from the governor. And that's going to be a leverage point that they're going to have on you, and that's going to make it more difficult for you to charge. I mean, the thing about civil disobedience is it is disobedience. There's a law and there's a rule, and you are violating it, and you are accepting the consequences that come with violating it. Now, the scope of the economic damage to this state is not to be understated, and in particular a state that depends on tourism and that depends on people from out of state coming in here heavily during the summertime for a lot of reasons, and that is what puts a lot of money into this economy that in turn helps pay for all the service providers, all the contractors, all the residents who live here who need other services. Maine, I think, was justifiably identified as one of the most financially vulnerable states, and these people need to be ringing the legislature and the governor's phones off the hook. And I think some unrest and some protest is going to have an effect, because I think that people are ultimately going to have to enact. I think, as we've made clear, we think that the democratic process is really the only outlet for challenging a lot of these laws. But the answer is more people may do that, and I think there are some enforcement issues with respect to particular individuals or folks, but there are penalties to pay for doing that. And my guess is that as a matter of law, any responsible lawyer would advise people, say, yes, you're going to risk some liability or even potentially criminal penalties if you disobey these orders.
Well, the related issue that was raised in one of the comments is liability. And of course, I actually had one of the last burgers at that restaurant up in Bethel before they closed the ski areas, and a donut. And so looking forward to going back as soon as possible. But, there's a liability question. If he's going to, if you're going to open your business and let's say there is someone sick from Boston that comes up and for a burger, and now you've got 10 people who ate there and spent an hour in the restaurant and potentially are ill. I mean, I wouldn't have high hopes that he would be able to save that business under those circumstances. And I'm not sure he could even get insurance for that loss, because all the insurance policies have virus exclusions. So, I mean, it is a very risky proposition, both, will the state ultimately be successful in imposing whatever sanctions it imposes, but also from just a liability standpoint. I mean, he's not going to be handing out waivers to people in line. I didn't see that on TV, and asking them to agree. Well, if you should happen to get ill, you're not going to sue. I don't know that that'd be enforceable anyway.
And if that person, having disregarded Patrick's advice and then disregarded Sig's advice, then came to me and said, should I open? After repeating what you just heard from Patrick and Sig, one of the things I would drive home is, if you're going to do that, you need to do it in a way where you're meeting the social distancing criteria that's out there, if for no other reason than to be able to show Augusta that in fact this type of business can do this and reopen and be safe. But if you end up defying the orders and then have mass gatherings with people in close proximity, frankly, you're just hurting the cause somewhat down the line.
All right, so we have enough time for one final question here, so I will get to it really quick here for you. What is the legality of executive orders that compel citizens to take specific actions? And specifically here, what we're talking about is things like wearing a mask in public. Does this exceed the government's authority? Can they really tell us to do that kind of thing? I'm not sure if we lost Patrick again, but it might just be you saying, Keith.
I'm here again, and I have complaints about the availability of reliable broadband service in Maine, but I'm probably not the only one who has that too. It's a lot of the same thing. I mean, the answer is, what is the level of intrusion? What is the support that the government can offer for the demand? And is it being arbitrary, or is it deemed a reasonable public health measure? It's not different than the standard that I think SIG has laid out for vaccination and some of the other things. There are a number of things the government actually compels us to do, whether that is, clothe ourselves in a particular way, or conform our conduct or our language to a particular, time, place, or manner, that can pass constitutional muster. And a lot of it measures on how consistent it appears to be with accepted scientific basis that is going to be presented in court, and how significant the risks are.
My sense is that it's a relatively minimal intrusion on your privacy, and particularly the way it's being implemented, where if you can't wear it because of health conditions, then you're not expected to wear it, and no one's going to ask you about your health condition because of HIPAA violations. And so it's really in some ways, it's guidance to the individuals with not much teeth behind it if someone chooses not to wear one.
All right, great. So that is basically all the time we have here. So I guess before we let everyone go, I don't know if there's any parting thoughts that our panelists have about the situation we live in and the legal implications of everything we've been talking about. But I did want to give one final opportunity to everybody to weigh in on something if they had some thoughts or questions that we didn't get to that you think are important for us to talk about really quickly. Would love to hear from you guys if you have any thoughts in that regard.
I mean, I'll just say the longer it goes on, the stronger the chances of being able to legally challenge it are, but that the remedy in this case is with your elected officials, and you have to do everything you can to get through to them to communicate where your interests are being harmed and why you need them reformed. As I said at the beginning, judges are not going to be reluctant to get involved in this, and I'm not so sure that that's a bad thing. As a general matter, my view is that judges should probably defer to the legislative choices that the people have made more often than they otherwise do right now.
I'll say from my standpoint, this is sort of an ounce of prevention is worth a pound of cure situation. If we could have gotten ahead of this problem at the front end, we never would have been faced with the types of extreme limitations on civil liberties that we're now looking at, and realizing that the government in a government declared emergency, whether you agree with the gravity of the emergency or the way it's described, once it becomes an emergency, the government's powers are really at their height to impose these kinds of limitations. So it really behooves us all to look at how we can avoid creating circumstances that then lead to these kinds of extremely onerous impositions on our civil liberties and our economy and so on.
Just briefly, I mean, what we're seeing is everyone's walking a tightrope between protecting sort of the public health and welfare while trying to get this economy restarted and get the state opened again. And I think that frustrating as it may be, we have to have some patience, but also try to play a role in defining the process going forward. And in the meantime, trying to keep ourselves and our families safe and healthy. We'll get through it.
All right, well, that pretty much does it for us. Before I go, I should mention that we do have a raffle winner by joining us on the program here today. You are automatically entered to win our raffle, and today's winner is Christy Miner. So congratulations go out to you. Really appreciate not only you, Christy, joining us, but the more than 120 people that were on this throughout. So to our panelists, a quick thank you for providing their legal perspective. And I think one of the enduring lessons that we've learned from this conversation is that our involvement as citizens in the process from the very beginning prior to all this happening and what we've had our legislature doing and the laws that we make and the grants of emergency powers and whatnot are all things that we can change and could have changed 5 years ago, 10 years ago, and can change in the future. So I would encourage everybody who's on this call, if you have particular issues with how the government acts and what is actually being done right now, it is an excellent argument for being as involved in this process as possible in an ongoing manner throughout time. So again, thank you very much to our panelists. We really appreciate you joining us here today, and thank you to our audience for listening to us. We look forward to the next event like this coming up next in the future. Appreciate it, everyone. Thanks a lot.
Thanks, Matt.
Thank you.